So every policy is complex, as you both say. How can a broker cover every single condition in a policy to ensure that the policyholder is aware?
Well, clearly that can't be done. That's not practical. But policyholder is entitled to have certain things drawn to their attention and explained. So we would say, based on the things that typically occur that will trap a policyholder, that probably one of the most important things for a broker to do is to explain what the claim notification conditions are. How do you notify a claim? When? Then there are warranties. What warranties in a policy are particularly important. And so a broker should always declare what warranties there are and explain how they operate. Then similarly, the conditions of the policyholder needs to understand what he should and shouldn't do during the currency of the insurance. And then finally, there will be a number of endorsements in the policy that perhaps extend the cover, but more importantly, there will be endorsements in the policy that restrict the cover, and that should always be excellent.
Yeah. I think above all, there is no tick box answer to that question. And I'm speaking from the position now of where it will be judged if something goes wrong. It will be judged by reference to whether the broker has demonstrated in the overall handling of the insurance an awareness of the pitfalls of a typical insured of buying that insurance, and having brought to the attention of the insured these responsibilities and these pitfalls, but bring it to their attention in a way that a reasonably responsible policyholder would be likely to respond and take notice. And therein lies part of the problem, because the way that we're transacting insurance nowadays, largely online and with here's a whole load of documents, go and read them and tell us something wrong. When these things go into litigation, into court, they don't like that at all, because they say, well, you haven't really brought it the notice of the policyholder, and even a sophisticated policyholder. So particular care really needs to be taken in relation to terms that would be considered unusual. And that's a subjective judgment. For example, a condition in a motor policy that excludes cover for an accident following a driver having drink and drugs test. That might take the insured by surprise. Actually, they could lose their insurance cover just by that condition. They probably wouldn't know about it unless somebody brought it to their attention. And you've got to think as a broker, what is an unusual condition in the context of my insured, and see what you can do to bring it to their attention.
Roger, there's a principle that I've not heard discussed for some years. It's the principle of knowing your customer.
Yes.
And I do wonder, see, we're looking at this from a fairly clinical point of view, but if a broker spends time really getting to know the customer, then I think then instinctively the broker will know what parts of the policy really need to be reviewed and discussed, because they will know something about their client's level of comprehension. They will know something about the business, if it's a business policy. And I think that will help the broker to sift through all the details to decide which things really need to be discussed.
Well, I think that's probably true, even where they have been with the same broker for a number of years and got a very good relationship. It's not uncommon for the insured to turn around eventually and say, well, I didn't know that, you didn't tell me that. What that brings you to is making sure that when you do make these points to your client about these unusual conditions, or they should do it in writing.
Thank you both. The second question we have is, Is it fair to the common policyholder to find conditions and warranties buried in a very lengthy renewal document?
Well, the straight answer to that is no, it isn't fair, but it's the way that business is transacted now. We have to deal with it. Mike, where would you go for that? What would you say?
Well, what I would say is that from the policies that we review when there's a dispute, we find that there's no common approach to the listing of conditions and warranties. We would expect a condition or a warranty to be placed in the policy very close to the cover which it relates. But that's not always the case. You can find that on page 10 there's a list of perils that are covered by a policy, but the conditions and exclusions don't appear until page 30 or 35. And we don't think that that's fair. We don't think it's workable. And the other tendency that we've observed is that whereas traditionally you would have a policy document with, say, 40 or 50 pages, a schedule 1 or 2 pages, now we're finding that some of the schedules are almost as long as the policy. And you find that some of the conditions and warranties are in the schedule and the rest are to be found in the policy. So they're all separated.
Yeah.
To be found in different places. So we feel that the industry has got a lot of work to do to bring the warranties, conditions, and exclusions all together in one place and much closer to the cover to which they relate.
Yeah, I think that's right. I mean, I can see a very good case for saying that the industry could usefully start to adopt a standard approach to the general layout of a policy. You know, they can still keep their differential, but fundamentally, in my opinion, what a client needs to know is you're covered for your insurances, but be aware you're not covered for these things. You are required to do these things. You mustn't do these things. This is how you must notify a claim. And if you were to have that more or less on the front page, yeah, that's the first thing they read. Bring to the client's attention the fact that this policy isn't all about the cover. It's more about what isn't covered and what you've got to do not to prejudice it. I think that probably answers that question, because if those things are buried away in the policy, no, it isn't fair. No.
Thank you. The third question we have is, does the IPID not go some way to appeasing the issue of information overload? Or do you think there could be an in-between length between a schedule policy and an IPID?
Well, this comes to the fact that there's so much documentation sent out, doesn't it? Quite often the IPIDs are part of the voluminous documentation that people get. And in our experience, the insurance attention span of a policyholder expires the moment they've given instructions to go on risk. That's the experience that we see. People actually spend some time perhaps working out how much they're going to pay for insurance and what they're going to get. But once the policies are, I shouldn't think more than 0.1% of the population ever read them until they have a claim. Now, you could say that's their problem, but it becomes our problem, the industry's problem, when something goes wrong. So I think you've got to expect that anything which is sent after the contract has been closed is unlikely to be read unless you bring it to their attention in a way that it really is difficult not to miss it. How we do that, you know, it's a challenge for the industry. But
well, Roger,
what do you think?
But bearing in mind the information overload,
Yeah,
I don't find the iPad in the slightest bit useful. I really don't think
tend
it
to
serves
agree
a
with that.
purpose
Yes.
these days. I mean, that's my personal view.
Mm.
If you're going to highlight anything to a policyholder, either at inception or renewal, it's the statement of fact.
Yes,
Because
that's the most important document.
it's errors on the statement of fact that
Yeah.
generate the majority of problems when it comes to a potential non-disclosure. So
Yes.
it's difficult for the policyholder opening up an email with maybe half a dozen attachments. We know that many policyholders never open any of them. So if the insurer or the broker is going to do something to help that information overload, focus on this statement of fact first, and
Yeah.
then find a way of highlighting conditions, warranties, and exclusions.
I think that's right. Yes.
I
think
really
the
don't. I
IP.
really don't think the iPad with the iPad is doing anything useful at all.
No, but I think that it is probably a legacy of when we started with the FCA or FSA regulation. It was a good idea. But you know, one of the things that comes up time and time again in insurance dispute litigation is the fact that quite a lot of the documentation is unintelligible to most people.
Thank you. We'll go on to question 4. I don't agree with the continuing duty of disclosure, but I can see why underwriters would want to try to enforce it. For example, a factory worker might decide to deliver a few Amazon parcels a couple of days a week to help pay increased household bills. Is this new activity really any different to taking up a new sport or babysitting a neighbour's children? How can an ordinary person know what an underwriter can reasonably expect to be told in the course of a 12-month policy?
View on this is that everybody would be much better served if we reverted back to the traditional basis of disclosure of information, and that is that it's all done either at inception or at renewal. Clearly, there are certain things that will need to be disclosed during the currency of the insurance, such as if you insure your house and you move to a different address, clearly that needs to be disclosed. But we saw one example on a continuing duty of disclosure where the policyholder not only had to disclose during the policy year if they had a change of job, they would also have to disclose during the year if they became unemployed. Now, first of all, that will come as a huge surprise to most people, and so consequently, it's unenforceable and unworkable. So why have something incorporated in this continuing duty that just isn't going to work?
Yeah. I think this is sort of the tip of the iceberg, really, for continuing duty of disclosure. You could argue that a prudent underwriter will factor into his underwriting the fact that things are going to change within the insured within the course of a 12-month policy. I mean, it's just the way it is. And we've been insuring people for 300 years without having to have a continuing duty of disclosure because, frankly, most people wouldn't think about it. They wouldn't know what it is a prudent underwriter would want to know anyway. So I'm with Mike. I think this is a very dangerous precedent to be setting. And I know that more and more underwriters are beginning to say, well, we can do this because it gives us an opportunity, you know, to say, well, you didn't tell us so and so, and therefore you may not be paying your claim. It also goes to the other point that if there is a continuing duty of disclosure, that is a very, very onerous term in the policy. And it does require, particularly brokers and agents, to bring it to the attention of the insured. And I don't think they ever do.
No. And picking up on motor insurance, when the underwriter assesses the risk on day one, he will know that some policyholders, for instance, will be stopped for speeding at some time during the year. That's part of the risk that they're taking on. And traditionally, if you pick up an endorsement for speeding, you would declare that at the following renewal. Now, more and more insurers expect you to declare it during the policy year. So as soon as it happens, you're supposed to notify the insurer. And I'm not too sure that that's, I don't think that's fair. I don't think it's workable. I don't think it's right. And we even saw one, Roger, where the policyholder was supposed to disclose at midterm if they had an additional driver who had his own car insurance and had an accident in that car, that would also have to be picked up. and disclosed in advance of the next renewal. And
Well, it happened, does it?
these occurrences are so remote from anybody's comprehension or forethought that it just doesn't work.
Well, the other question is actually, why does the underwriter need to know it? You know, what's he going to do with the information? It's, particularly in the days of digital communication, is that information going to go into a silo somewhere and have to be brought out in the event of a claim? I'm not for it at all. So I think that, excuse me, the big issue with the question said, I don't agree with the continuing duty of disclosure. Well, frankly, neither do we, and neither do we think that it's necessary if it's underwritten properly at the first instance. View.
Thank you. We'll go on to the fifth question. If a broker tries to engage the client each year in discussions concerning their insurance, but the client refuses to engage properly or in good time, what more should the broker do? Should we decline to accept renewal instructions, or should we take what the insured has given us and just get on with the placement?
Ooh,
Well,
Roger, I think this is the sort of thing that you come across in your expert witness work.
I see this. I've seen 3 of these this year, and we're still only in April. This is a horrendous problem. It really is a horrendous problem. The bottom line is that brokers will often say, that's what my client told me, that's all I have to do. Well, it isn't as simple as that. If a broker suspects that a client is not really paying attention and not giving due diligence, if you like, to his insurance, best thing to do is to walk away and not act for them. I can't be more clear than that. It really is a danger. If you do take it on, and most brokers will say, well, we can't do this, we need the business. I can't tell my boss that I'm letting it go because I don't trust what my client's saying. I understand all that. I've been there. I was broking for 33 years. I know exactly what it's about. But the law is getting much more pernicious against people that accept business. And I've got 3 cases at the moment. One of them is a very serious case where actually the broker knew that the insured was lying about certain things and told those lies to the insurer. And it's all come undone now because there's a massive total loss under insurance, and it's horrendous to see it. And actually, the broker would have done an awful lot better than simply say, I can't act for you. I'm sorry, but I just don't think. And how you do that is up to you and the relationship. But it's usually best to get your boss to do it. But I don't think there's anything else to say. If you
Roger, didn't you have a case where the insured instructed the broker to reduce the sum insured by quite a large amount on the basis that he said he couldn't afford the premium?
yes,
What should the
this was
broker have done?
the sum insured on this case was originally £7 million. The insured reduced it to 4.5 after 2 years, and then instructed a new broker. No, it wasn't a new broker, so it was the same broker, to reduce it down to 1.05 million. And what was interesting about that, and this has been through the legal process, I can talk about it a little, is that the underwriter was the same all that period and didn't blink an eye. And one of the things that came out quite clearly in the court was, what was the underwriter doing? He must have been asleep at the wheel. Surely he must have said, something's gone wrong here. Can you explain to me why this property is suddenly worth so much less after 7 years? And the broker was in a terrible state. I mean, just didn't have a leg to stand on. But the broker had said, and did say in the witness statement, they were my instructions. I carried out my client's instructions. And I'm afraid the judiciary have taken a rather different view. And of course, what he was saying on behalf of the insured, the insurer, what he was saying on behalf of the insured to the insurer was simply not true, and it was a breach of material information. So no, just walk away.
Thank you. And we'll go on to question number 6 now. In your example with a contractor, if the broker had written to the client at each renewal and specifically asked them to review all documents and had enclosed the statement of fact and schedule, and furthermore advised the client of the obligations to check the documents, has the broker discharged their obligations? In short, does the broker